I had some at my house, which I disposed of.
In your nose or what? You what?
I used it and then
Oh, you used it then. Okay, so it didn't stay on the tray.
honestly, I don't see how.
Oh, really? Hold on. You know what? The thing I hate more than anything is when somebody lies to me. I don't know how he's going to do treatment. And the other thing is, he doesn't test when he's supposed to test. So it seems to me I have two options. I could let him go and say, oh, well, best wishes. Or what I can allow him to do is go back out there, use some more cocaine, and kill somebody else.
Thank you, Judge. I have spoken to Mr. Edmonds about this case. It's going to do some further look at the matter to see where we stand in terms of an offer. We're asking just for an adjournment for a couple of weeks of the PCC. And then I need to address his, it's not a bond violation yet, I don't believe, but it's a bond report where Mr. Croy given permission to test in Genesee County. He signed up for a program, DNA testing in Genesee County. That program did not release testing results to the community corrections unless he was.
Well, hold on a second. That's not what I have. Do you have his progress report?
The one that I have, I do have a progress report.
From August 28th?
I don't believe that's the date. Let me check.
In terms of his testing, I have so he's here on an operating while intoxicated causing death. So then he got tested on the 16th he was ordered. On August 20th, and he's positive for cocaine.
Correct, Your Honor.
Then on the 22nd, he didn't appear for his testing.
That was when I was setting up to be tested in Genesee County. I didn't have to test again because I had just tested. I was just signing up to test in Genesee County. And I called the lady down here to let her know right away.
All right. Let's go back a moment because I don't think he's been before me.
I don't believe so, Judge. Just asking for a 2-week adjournment to see where we stand in terms of the potential.
Why is he testing positive for cocaine after getting charged and arraigned on an operating while intoxicated causing death?
Because he used cocaine, Your Honor. Obviously. I don't think he's.
No, it's a fair answer to my question. I'm just saying why.
Yes, Judge.
Why? I mean, why is he using anything?
Well, my understanding is he is not any longer.
What?
My understanding is he is not any longer, but he previously was. He began testing, transferred that testing to Genesee County per the instructions he was given at arraignment. He's been testing there, but they are not reporting the results here unless he is positive. They have not called him to test this week. He's called them twice a day to go test. They have not called him, so he went over today to community corrections and tested here. And he is going to change if the court allows
him. He tested here today?
Here this morning.
What is it? Do we have results on that?
I don't have it.
I don't have anything yet.
I was informed about it this morning myself.
So, go ahead, Mr. Green.
Thank you, Judge. So rather than do the Genesee County testing that authorized to do that does not send the reports as community correction would require, he has signed up again today to test here and do all of his testing here, although he does not live here. He has a relative here with him who has agreed to drive him back and forth.
Okay.
That testing, if he is allowed, Your Honor.
What was the intoxicant in the primary offense?
Okay.
He's charged. I just want to make sure. So I have it clear in my head.
You do.
He was charged with operating while intoxicated causing death.
Yes, Your Honor.
The intoxicant in that charge is cocaine.
Yes, Your Honor.
He's in arraigned. So now he knows what he's charged with. He's told to go to community corrections. When he gets to community corrections, mind you, 4 days later, he tests positive for cocaine.
I had some at my house, which I disposed of.
In your nose or what?
I had it in a tray and I disposed of it.
You what?
I had it in a tray
and then you just smoked it.
I threw it away.
You threw it away? Where did you throw it? It's gonna be a long conversation. Where did you throw it away?
There was a little bit left. I
know.
I disposed of the tray.
You what?
I used it And that,
Oh, you used it then. Okay, so it didn't stay on the tray.
Right.
and I disposed of the tray.
Yeah, yeah. Okay, well,
And since then, I haven't touched it since.
okay. He probably stopped using because he's coming today. So somebody needs to answer for me. Why was he using after being arraigned
I mean, obviously,
on this charge? And why was he using?
I don't,
I have my theory, Your Honor.
I don't think there's any answer to
Oh, darn.
satisfy the court as to why.
And by the way, you're still using.
Honestly, I don't see how. I
Oh,
have-
really? Hold on.
I've never
But you know what? The thing I hate more than anything is when somebody lies to me.
Honestly, I'm not.
Okay. We'll just make sure that you, because it has to be in your system in order for you to test positive. And that you, that it's been fine.
Counsel, approach briefly. You want to see this? That's my copy though. Yeah, this is the one he took today. No, not at all. We need all of this on the record.
And the last positive, 22nd to 7 days later.
Yeah. 7 days later. And a little bit he threw away. That, go ahead, I'm sorry. I'm messing up your story.
Oh, I know.
Okay.
But all I've done is I've used it in the chair that I saw. I've used it. And that was it.
When it's second,
Well, no, I have not.
okay. Well, we'll tell them that, but, you know, medically.
I know. I want to do this. I want to the truth.
Okay. To answer your previous question, Judge, why?
Oh, he's positive for cocaine.
Judge. And
Just so that we know.
thank you, Judge. And to answer your previous question as to why he's still using after being arraigned,
Sure.
clearly he has a problem, Your Honor. There's no answer I can give you that can justify use of cocaine after arraignment when it's an illegal. He doesn't have any type of special license to allow him to use cocaine, Judge. So clearly he has a problem. He is willing to fix that problem when he's testing there. He is working and he did voluntarily come here today and take a test. So he's asking you to not say that.
Right. No.
No, you have to stay.
Right, anything else?
All I can say, Your Honor. So to the positive test, Your Honor, I have no explanation aside from what he already told you.
Which positive test?
The
First one or this one?
The first positive test. Your Honor.
Oh,
The
okay.
explanation he gave you is that he used it and then threw away the tray. After he was arraigned, after he was ordered not to use, have no explanation, Your Honor. He'll just ask for mercy from the court on that, and he is willing to get any treatment that the court would allow him to take place.
Except that he can't follow the court's order. I don't know how he's gonna do treatment. And the other thing is, he doesn't test when he's supposed to test. So it seems to me I have two options. I can let him go and say, oh, well, best wishes. Or what I can allow him to do is go back out there, use some more cocaine and kill somebody else. I'll let you know. Not doing it.
Understood, Judge.
Defendant's bond is revoked. Defendant remanded to the Washington County Jail. I'll set his hearing September 12th, 2024, 9 a.m. for probable cause. Court does call the case. People versus Jade Lathan.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lathan, who is approaching.
Your name, ma'am?
I'm J. Ruth Bay, the nationality of Moorish American, beneficiary of the Principal Jade Lathan, and I'm making this special appearance at District 15, Michigan Court of Law under threat, duress, and coercion. I'm asking the prosecutor to dismiss this case on the grounds that there is no injured party. Plus, I have the right to a speedy trial, and this is the 5th time I've made an appearance for this in the case in the court of law since February 2024 for the arraignment. Since the arraignment, when the Ann Arbor Police Department apprehended me unlawfully and kidnapped me, forcing me to take fingerprinting and a mugshot when I am not a criminal. Officers Morgan Parker, 15400, and AA Condolis, 02002, claimed I fit a so-called description and also violently attacked me and produced a false police report against my person. These officers falsely accused me of committing crimes that the tapes do not show me doing at all. These tapes do not show me doing at all any of the things that I'm being accused of, as I've never harmed another person in my life and certainly not an officer of the law. I have also not disturbed the peace, and I have on file with public defender Kenneth Overwater right here to my left, a character letter from my former teacher proving that I've always been well-behaved, a well-behaved student, and have always gotten good grades and have no history of foul play or violence, which is still true to this day. My legal representation on the day of the arraignment on February 2024, who helped grant me my freedom on bond, has already stated on the record that I have no history of violent offenses, which is the truth. And I assume why I was granted my freedom from police custody. I would lastly like to say that on March 11, 2024, I was denied two main sources of evidence for my case via my personal FOIA request that would have easily shown my innocence. These two things are the mobile gas station cameras, and that will show the young boy already on the phone when I walked into the gas station. But either way, I was not at all acting out of the ordinary or belligerent. I was nothing but kind to everyone in that store. And I'm nothing but peaceful, and I'm saddened that I have been accused of behaviors that are not true. And I would like to exclaim that I'm a victim of a false 911 police call when I had no idea I only know that because of the police report that I got after the fact. I humbly ask both the prosecutor and the judge that this case be dismissed because I have school and I have church to attend, and my college studies have already began on August 26th at the community college. And I'm asking you to grant me my justice from this, taking up my time, because my time is very valuable to my community and I would once again like to motion to settle this case for full dismissal in a speedy manner, because this case has already been in default judgment since the date of March 7th, 2024, and I yield.
All right, so that we know that the review of the court's file, I've heard everything that the defendant has said. Court's review of the file, that none of the requests to adjourn were at the request of the people. It was always at the request of the defense in terms of any delay in these proceedings. Secondly, I do not need a response from the people. If I consider that a motion to dismiss, that motion to dismiss is denied. Where do we need to go now, Mr. Overwater?
Just be asking for an adjournment of the probable cause conference.
Any objection from the people?
No, Your Honor, I have offered a misdemeanor offer of 1 count of intent resisting obstructing the police. I'll leave that offer open to the next CCC.
September 19th, 2024, 9 a.m. In this matter, thank you.
A man charged with operating while intoxicated causing death walked into court hoping for another chance. But just days after being arraigned, he tested positive for cocaine again. When the judge asked why, the defendant admitted he had used the drugs after his arrest. The courtroom fell silent. The judge wasn't convinced by the excuses and said the